having identified the President as a person with the authority under Article 131(1)(e) of the Constitution to ensure the protection of human rights and fundamental freedoms and the rule of law, and the function under Article 132(5) to ensure that the international obligations of the Republic are fulfilled through the actions of the relevant cabinet secretaries, and the mandate under Article 254(2) to call for reporting at any time on any particular issue, in this case of the human rights reparations, and the Kenya National Commission on Human Rights as a principal organ of state under Article 59(1) for ensuring compliance with obligations under treaties and conventions relating to human rights. The court considers that the development of a suitable framework for adoption by the executive and parliament as necessary for the reparations of the violations subject of the consolidated petitions should be put to the Kenya National Commission on Human Rights, with mechanics as to establishment of an expert group of consultants under the provisions of its mandate in the Constitution and the statute providing for its operations. The report of the Kenya National Commission on Human Rights to the President shall then form the necessary executive acts and legislation. Consequently, the appropriate remedy in this petition is not the striking out or quashing of the proclamation and the Gazette appointing the panel, but allowing the necessary amendment as necessary to be done to bring them in agreement with the constitutional statutory scheme for calling for a report from the Kenya National Commission on Human Rights and report, publication and publicization thereof pursuant to Article 2542 and 3 of the Constitution, and the grant of other appropriate relief for the specific discharge of the mandates of the relevant state organs in addition to the preparation and recommendation of a framework for reparations. It appears to be a case of good intentions, bad execution, and it is not necessary to quash the proclamation if it is suitably amended to stay within the President's constitutional lane, in the words of counsel for the panel of experts. It will only be necessary to quash the proclamation and the ensuing Gazette notice if the amendments are not effective within reasonable time, herein set at 30 days, and the declarations of invalidity and judicial review orders, statutory and prohibition, shall then issue. Therefore, for the reasons set out here, the court finds that the consolidated petitions herein are partially merited and makes the following orders. A declaration that the President is not constitutionally empowered to constitute a panel of experts to advise on the design of a framework for compensation of victims of human rights abuses, a matter which falls in the competence of the Kenya National Commission on Human Rights as the principal organ states in ensuring compliance with obligations under treaties and conventions relating to human rights under Article 59(1)(g) of the Constitution. 2. The President's proclamation dated 6th of August 25 and the Gazette notice number 12002 dated 25th of August 25 are constitutionally invalid. 3. The court suspends the declaration of invalidity of the proclamation and Gazette notice constituting the panel of experts for 30 days, to allow the respondents to secure the amendment of the proclamation and gazette notice subject of these consolidated petitions to accord with the findings of the court. In default of amendment within the period of 30 days granted herein, the judicial review orders of certiorari to quash the proclamation and the gazette notice subject of this consolidated petition and prohibition to restrain their implementation shall issue as prayed in the petition. Without prejudice to any presidential proclamation calling for a report from the Constitutional Commission on the issue herein, the third respondent, Kenya National Commission on Human Rights, is strongly advised in the language of the Constitution to take steps to secure appropriate redress where human rights have been violated, end of quote, by way of preparation of the necessary framework for reparations, even for other violations of human rights and for legislative enactment. In the meantime, the order halting the proceedings of the panel of experts remains in force. And in view of the public interest nature of the matter and the apparent bona fides in the pursuit of a framework for reparations for victims of human rights violations, the court does not make any orders as to costs. For compliance, the matter shall be mentioned before the court on the 20th of January 2026. And the full reasons of this judgment shall be uploaded on the court tracking system shortly. That is the order, judgment of the court today, the 4th of December 2025. Thank you very much, and I'm sorry for the internet outage in the course of the delivery of the judgment.
We are most obliged.
Most obliged, Your Lord.
Thank you,
Lord.
Most
obliged.
Pay for a copy of the judgment.
Yes, it will be uploaded on CTS shortly.
My Lord,
Very well, Your Lordship.
My Lord, may the record reflect that I, Ochiel Dudley, attended judgment
Yes.
on behalf of Elisha Ongoya for the 21st interested party.
Should be Mr. Goyen, 21st IP, LSK.
Thank you, my Lord.